Today, obviously, we usually do it on a Thursday, but kind of like our little fireside chat. So I want to introduce first Josh Blackman. Josh is a national thought leader on constitutional law on the United States Supreme Court. Josh's work was quoted during 2 presidential impeachment trials. He has testified before Congress and advised federal and state lawmakers. Josh regularly appears on TV, including NBC, CBS, ABC, Fox, and the BBC. Josh is also a frequent guest on NPR and other syndicated radio programs. He's published commentaries in the New York Times, Wall Street Journal, Washington Post, and leading national publications. Since 2012, Josh has served as a professor at the South Texas College of Law, Houston. He holds the Centennial Chair of Constitutional Law. Josh is also an adjunct scholar at the Cato Institute. Josh has authored 3 books. His latest, An Introduction to Constitutional Law, was a top 5 bestseller on Amazon. Josh has written more than 5 dozen law review articles that have been cited nearly 1,000 times. Josh was selected by Forbes magazine for the 30 Under 30 in Law and Policy. Josh is the president of the Harlan Institute and founded Fantasy SCOTUS. He is the internet's premier Supreme Court Fantasy League. And the internet's Supreme Court Fantasy League. He blogs at is it Bullock?
Pollock.
Bullock, thank you. Conspiracy and Tweets. Josh also clerked for Danny Big Boggs on the Sixth Circuit and Judge Kim Gibson in the West District of Pennsylvania after law school. And then we also have Diana Thompson with us, who is an AUWCL alumna. So Diana.
I went to George Mason to holding against me.
So we did graduate the same year.
We did.
Wow. So Diana has been a lawyer at Beckett. A lot of you probably know what Beckett is. It's the basically elite institution for religious liberty. And she's been there since 2009. Her work has included domestic and international litigation, including defending the Pledge of Allegiance in public schools and supporting the right of New Zealand's Jews to have access to kosher meat. Diana has been quoted in the Washington Post, the Boston Globe, and the Christian Post. She's been featured on Christian Broadcasting Network Television, Eternal Word Television Network, and C-SPAN. She's been involved in a lot of different famous cases like the Burwell Hobby Lobby case, Wheaton College v. Burwell, Moses Rusowski, Singh Carter.
Yeah.
Thank you. I can't read it. Singh v. Carter and Intermountain Fair Housing Council v. Boise Rescue Mission Ministries. Diana graduated summa cum laude from UWCL in 2009, where she was articles editor for the American University Law Review, practiced human rights law through the International Human Rights Law Clinic. She received her BA from Wheaton College and graduated magna cum laude in 2004 with a major in international relations. So please give it up for our guest.
Thank you so much. I was coming to a law school campus after election day. I was kind of nervous. I spoke at the University of Oregon Law School the day after the 2016 election. The place felt like a funeral. It was actually very grim. People were just kind of moping around like, moo, moo, moo. So I guess after last night, people aren't that upset. It could have been worse or it could have been better depending on your perspective, but things are not as bad as it could have been. So our topic today is religious liberty in the Roberts Court. And we're going to sort of divide our talk in half. I'll try to focus on Establishment Clause stuff, and Diana will talk about free exercise stuff, which is not a perfect law because they often sort of intersect, but we'll try our best to split them up this way. The Roberts Court is very divided in many regards. Even though they're all conservatives, or at least majority conservatives, they don't always agree on things. Some are more keen to roll back precedent. We look at Justice Thomas, we look at Justice Gorsuch. Others are more hostile to the administrative state. Others are perhaps more moderate and want to go in a more incremental fashion. But I think one issue on which the 6 conservatives are lined up to a T is religious liberty. And it's really manifested in the 2 clauses we'll be talking about today, the Establishment Clause and the Free Exercise Clause. Settled doctrine is no longer settled. Cases from many years ago that we thought were more or less chiseled in rock are now being sandblasted away. And it's happening in a very conscious direction. Let's start with Establishment Clause. As I'm sure we all know, or maybe you will know if you took the one First Amendment class offered here, the Constitution has a provision that says Congress shall make no law respecting an establishment of religion. Now, as many of you probably know, in 1791, when the First Amendment was ratified, there were actually state-established churches. It's true. Many of these established churches existed till the 19th century. So there's an argument that the purpose of the Establishment Clause was to prevent Congress from messing with the state churches. If that argument's correct, then the states would have complete discretion to incorporate religion into the government as they see fit. For much of the nation's history, the Supreme Court had little to say on the Establishment Clause. It really wasn't until the early and mid 20th century that the court started to get involved. And one of the first big cases we have was Engel versus Vitale in 1962. Right? And before Engel, we had Everson versus Board of Education, 1947. Both of these cases latched onto a principle that became very popular. The notion of a separation of church and state. How many of you heard this, right? You all heard this a million times growing up. And how many of you thought this was actually in the Constitution, the text? Quite a lot of you. It's not there. It's not there. I promise. It's not there. Look, I've taught Constitution. You will not find this phrase separation of church and state in the Constitution. Where did it come from? So President Jefferson wrote a letter to Group of Baptists in Connecticut way back in 1802. And he used this phrase, separation of church and state. Now, I won't go into the details. I think the Jefferson letter has been misunderstood and misread. But Jefferson wasn't a framer. He wrote this letter more than a decade after the first one was ratified. And it's not clear they actually represented the majority view on religion at the founding. But for whatever reason, the Supreme Court latched onto this conception that church and state must be kept separate. And this doctrine prevailed throughout the 50s, 60s, 70s, 80s, and really into the 90s. And it manifested many different tests. We all love tests, right? Remember the test for strict negligence, the test for breach of contract, right? What are the factors? But there are many tests for the Establishment Clause. We have something called the Lemon Test, a case called Lemon versus Kurtzman, which said the government cannot have an excessive entanglement with religion. We have something called the Endorsement Test, that is, the government cannot endorse religion. Something called the Coercion Test, that is, government cannot coerce people to engage in religious activity. And we have this hodgepodge of different tests that the court seems to apply almost at random in different cases. You never know which case will govern. As a result of these various tests, governments became afraid. They became afraid of violating the Establishment Clause. So whenever a government was considering whether to give some sort of protection to religion, they said, let's not do this. Let's pull back because we want to avoid running afoul of the Lemon Test or the Endorsement Test, the Coercion Test. And for about 30 or 40 years, this was actually good advice. Governments were actually well served to perhaps avoid inflicting the wrath of the Establishment Clause. Let me give you a couple examples of where this started to go backwards. Coach Kennedy is a high school football coach. Actually, he was an assistant coach, but he was an assistant football coach in a suburb of Washington. After games, he would do something different. He would go over to the 50-yard line, he would kneel, take a knee, and he would quietly pray. Now, sometimes the students came around and prayed with him. Sometimes students from other schools came around and prayed with him. He wasn't requiring any of his students to pray. He was just praying, and whoever wanted to join him was allowed to. All right, what happened? The school district said, you can't do that. Your prayer at the 50-yard line would violate the Establishment Clause. And in order to avoid an Establishment Clause violation, we're going to tell you to stop. Whether they fired him or not, it's actually some dispute. I don't really care. But they disciplined him. All right, that's case number one. Case number two is in Boston, the city of Boston, Massachusetts. At City Hall in Boston, there's a flagpole. And there's a tradition where people are allowed to give a flag to the city, and the city will raise it. Now, these flags can be for sports teams, the Patriots or the Red Sox, right? It can be for different countries, for different civic organizations. Every flag can be raised. And over the course of several years, hundreds of flags were raised until one group brought a flag that had a cross on it. Not a crucifix, just a simple cross. The city said, lemon test. No, we can't do that, right? We are afraid of getting sued for the Establishment Clause violation. So we tell this Christian group, no, you cannot raise your flag. Sensing a pattern here, right? In order to avoid an Establishment Clause violation, the government said, no, you can't speak your prayer. No, you can't fly your flag. One more case, Maine, okay? 20 years ago or 30 years ago, Maine was considering having a voucher program. They provide funding to private schools. They said, wait a minute, we can't provide funding to religious schools because that would violate the Establishment Clause. So religious schools were excluded. You went to a private school, military academy, whatever it was, you got your funding, but not a religious school. So in these three cases, from Washington, from Massachusetts, from Maine, the government wanted to avoid an Establishment Clause violation, so they basically denied benefits to people of faith. Now, how do you think all three of those cases came out the Supreme Court? All three of those were losers for the government. I'll take them a little bit out of order. In the Massachusetts case, by a 9-0 vote, 9-0, this is unanimous, Justice Breyer with majority opinion, he ruled against Boston. And he said there was an express form of viewpoint discrimination. That is, every other perspective was allowed to have their flag except the Christian group. What about the Establishment Clause, right? Wouldn't it violate the Establishment Clause to fly a flag with a cross? The court said no. The exact reasoning there is muddy because it's Justice Breyer, right? But the court said no, right? Merely flying a flag with a cross on it would not entangle the state with religion. It would not violate the separation of church and state. It would not endorse religion. It would not coerce people. It's merely a display of one civic organization's religious symbol. The state was not endorsing it. In that case, we had concurrences saying, all right, let's finally overrule the lemon test. We never apply it. It creates chaos in lower courts. It's very malleable. Let's get rid of it. But we're not enough votes for that yet. Let's go to the Maine case. It's called Carson versus Macon, right? The court holds, and I'll let Diana talk about this case a little bit more, but the court holds that providing the benefits to this group, these religious schools, would not violate the Establishment Clause, right? It doesn't matter if the money is used for religious use, right? Even if they use the money to buy, let's say, Bibles, that's okay. Because the government cannot discriminate against religious status, and they cannot discriminate against religious use. Giving this money to the religious schools would not violate the Establishment Clause. Again, 30 years ago, maybe Dan agrees or not, the court would have probably said that flying the flag would violate the Establishment Clause. I think so, at least. 30 years ago, the court might have said providing the money violates the Establishment Clause. Now we go the other direction. Now let me talk about the Washington case with the football coach. What did the court say? Allowing the coach to pray at the 50-yard line does not violate the Establishment Clause. What about coercion, right? Doesn't it coerce students? Imagine you're a player on the team, and then you see your coach praying. You think, I want some more playing time. Maybe I should go kneel with him. so to speak, pray, play, right? Isn't there evidence of coercion? You like that one? Is there evidence of coercion, right? That students are being coerced. The court says no. This is by Justice Gorsuch. The court says you need evidence of direct coercion, not indirect coercion, direct coercion. Unless there's evidence, the coach says pray or play, no Establishment Clause violation. This creates tension. In the past, the court has held that having a prayer in school is unconstitutional because there might be indirect coercion. Indirect. In the past, the court has said you can't have a rabbi read a very blasé prayer at a graduation because it might coerce high school students to sit through it. Here, the court says you need direct evidence of coercion. But we're not done yet. The Lemon Test, this controversial doctrine that's prevailed for almost half a century, about the same age as Roe v. Wade for that matter, right? The court overrules it. Or to be precise, they don't actually overrule the Lemon Test. They say that Lemon was abandoned. What does that even mean? Well, they couldn't overrule Lemon in the Kennedy case because it was an Establishment Clause case. It was a case premised on free speech and maybe free exercise. But the court basically said, we are treating Lemon as if it's done, it's gone. Stop citing it, ignore it, forget it ever happened, root and branch. So in 3 cases this term, the court has basically said all of the Establishment Clause precedents for the last half century are basically out. So what is now the test? I'll give you the answer. I don't like it, but the answer is text and history, whatever that even means, right? It's some historical-based approach. We look if there's some historical tradition that supports this practice, right? Is there any historical tradition of preventing coaches from praying 50-yard line? Of course not, right? This is a modern thing, right? Is there any historical tradition of denying funding to religious schools? Well, actually, there kind of is. They've been around for a long time, maybe about 100 years or so, or
That's not
more.
what we said in our doing research.
That's what you said?
Oh, that's not what we said in our research. That's not what the research said.
We have these Blaine amendments that have been around for a while, whether those are good or bad. And then you have the flag case. Well, that wasn't really a historical tradition test. But the new model is what's called text, history, and tradition, which, for however it falls out, is a lot more protective of the religious organizations than the old test, right? The Lemon Test put its thumb on the scale of separationism, right? Clearly. It made it very hard to have this sort of entanglement. The new stuff, the new doctrine, cuts the opposite direction. It makes it much harder for courts to stop various efforts by government to aid and assist religion. And again, on this matter, the court is fairly united, 9-0. I'm sorry, 6-3. The 6-vote block is pretty solid. I don't know if there will actually be another challenge to prayer in school. Maybe Dan will have some thoughts, right? If you read Gorsuch's opinion carefully in the Kennedy test, I think Levy-Weissman's is sort of been partially abrogated with the coercion doctrine or the endorsement doctrine, whatever doctrine it was. I don't know if you go back to Everson and allow full-on prayer in school. I think there actually might be more space for a religious communication in school, prayers at graduation, etc. Or they might leave those precedents in place. All right, I'll stop here, let Diana talk for a bit, and hope we have a good discussion later. Thank you all so much.
Sure. So, thank you, Matt, for the introduction, and thank you to the Federalist Society for inviting me. It's always good to be back at WCL. I was in the old building, So I probably get confused when I can come here, but nice to be here. I want to talk a little bit about a couple of the free exercise cases in the Roberts Court that they have in common with the Establishment Clause cases, that they are losses for the government, and they also lean on history as to tell us what the relationship is between the government and the religion clause. So when I'm going to talk about Ramirez v. Collier and Holton v. City of Philadelphia, they both address when the government has to accommodate religious exercise and areas within its control, and when it can meet strict scrutiny if it chooses not to accommodate that religion. Ramirez is a culmination of a series of cases that came to the Supreme Court on an emergency basis as midnight death row appeals involving the presence of clergy during an execution. The law at issue in that case is RLUIPA, the Religious Land Use and Influence Persons Act. That requires the government to meet strict scrutiny, show a compelling interest, and the least restrictive means of meeting that interest if it's going to substantially burden the religious exercise of prisoners. The prisoners in these cases also brought First Amendment claims, but in Ramirez, the court focused only on RLUIPA, so that's what I'll focus on here. Murphy v. Collier was the first case that the Supreme Court addressed this issue in 2019. They granted a stay of execution to a Buddhist prisoner. Texas had designated chaplains that it would allow into the death chamber at the time of execution to pray with the prisoner to have comfort of clergy at the time of their death. But it only had Christians in the chaplain. And so it didn't have a Buddhist chaplain, and it claimed that there would be security problems with allowing this spiritual advisor that had been meeting with Murphy in prison. And the Supreme Court granted it on an emergency basis, granted a stay of the execution. And Justice Kavanaugh explained in a concurrence that his vote was based on equality, equal access. So if Texas was going to offer a Christian chaplain, it had to offer a Buddhist chaplain. In the next series of cases, you see the states that do the most executions are Texas and Alabama. And in response to the Murphy stay, they both changed their policies to decline to allow any clergy in the death chamber. The problem with that they face under RLUIPA is that they have to show that they have no way to accommodate a religious practice that they were accommodating 5 minutes ago. The two cases came to the Supreme Court, Gutierrez v. Sands, and in that case, the court granted a stay of execution. They're trying to sort of slow the case down. They sent it back to the district court to allow the government to prove up its compelling interest and least restrictive means. But before that could happen in the district court, because those cases are, the district court is slow and the executions come fast, and another case from Alabama made its way up to the Supreme Court, and Alabama had refused to allow clergy in the death chamber, and in that case, the 11th Circuit granted a stay, and so Alabama appealed to the Supreme Court on the eve of the execution and asked the Supreme Court to lift the stay. The Supreme Court declined to do that, and Justice Kagan wrote a concurring opinion, joined by Breyer and Sotomayor and Barrett. So not totally in lockstep on religious liberty. This is not a 6-3 vote. And Justice Kagan explained that in order to meet strict scrutiny, the government has to explain why it can't accommodate a practice that other jurisdictions are allowing. And that in that case, the federal government was allowing clergy in the death chamber. Federal government was doing executions, and both Texas and Alabama had up until recently allowed this practice. So both Texas and Alabama reinstituted policies allowing clergy in the death chamber, and that brings us to 2021 and Ramirez. Ramirez had asked for clergy in the death chamber, his pastor, and Texas allowed it, but they wouldn't allow him to pray audibly or touch the prisoner at the time of the execution. The case went to the Supreme Court on an emergency basis. the case went up on September, I think the petition was September 7th, and the stay had been briefed by September 9th. The court granted the stay on September 9th and ordered argument on November 1st. So it was a very accelerated pace. And I think one factor of these cases is that the court was trying to address the way that these cases come up. So if you're looking at the 6 conservative justices, they're very concerned about delaying executions and gumming up the works for the government in these cases, but they're also very concerned about the pre-extent of the prisoners. They wanted to hear the case, so they set it for argument on an expedited basis. Second, we filed an amicus brief both at the emergency stage and on the merits. We also filed an amicus brief in the Murphy case and in the Smith v. Dunn case. And those were fun you find out that those cases are happening right at the last minute and you just have to stay up all night and
Yep. Yes, you do.
Those are fun briefs to write, but in our brief, we joined with Michael McConnell and we explained this is a practice that has been happening for centuries. It's tradition for there to be clergy at an execution and for the clergy to be allowed to pray and even touch the prisoner. The Supreme Court decided the case last March, and they cited our amicus brief to show that this is such a long-standing practice, and they said it as sort of as a baseline. The government has to respond to this. This is a long-standing religious practice that has been accommodated for centuries. Why can't Texas do it here? And you have to bring evidence that you can't do it. That you can't do it here, and Texas wasn't able to do that. This case is important because of its subject matter. It's important that we treat people with dignity, even if they've, because this is a fundamental right, even if they've committed the most egregious crimes. But it also gives us a window into how the Supreme Court is going to apply strict scrutiny to religious liberty claims. And it's an example of the court looking at a specific religious practice and applying it, and how over centuries we've seen this being accommodated, and that's one way that the court has looked at history. And then in the Fulton case, we have another longstanding religious practice, and that's religious foster care. And that was Fulton was the 2021 term, I think. And in that case, Philadelphia has a relationship with foster agencies. So if you are a foster family in Philadelphia, you have to partner with an agency that has a contract through the government. There's no nonprofit agencies that don't work with the government. And in that case, city officials told foster mothers Sharon L. Fulton and Tony Sims Bush in March of 2018 that they could no longer welcome foster children into their homes if they wanted to work with Catholic Social Services, CSS, an agency that they had partnered with and that affirms their faith. City left over 200 children in group homes or institutions. And they said that because of the agency's religious beliefs, that they couldn't certify a same-sex couple, but would instead help them find an agency that would help them, would complete their home study. And they did this even though no same-sex couple had ever come to Catholic Social Services to foster a child. CSS is one of 30 different private foster care providers in Philadelphia, including several who specialize in serving LGBTQ families. And the case went up to the Supreme Court. The Supreme Court ruled unanimously that the city's policy did not meet strict scrutiny. The first question is, does it get to strict scrutiny? The Smith case is the long-standing precedent that says that if a law is neutral and generally applicable, the government doesn't have to meet strict scrutiny. The city's non-discrimination policy said that it applied in all cases except when the commissioner offers an exception in his sole discretion. So the court held that even though the city had never given an exemption before, it had an off-ramp from the rule, and it had to explain why it couldn't offer that off-ramp to religious groups. And that made the rule not neutral and generally applicable. So that led to strict scrutiny. The court held that the question is not whether the city has a compelling interest in its enforcing its non-discrimination policies generally, but whether it has an interest in denying an exception to CSS here. So you need to look at the specific religious practice at issue. The court noted that CSS has a long history of providing care to foster children and families. They had been doing, this before even the government had gotten involved in foster care. And it noted that the city, though the city had important goals, allowing CSS to exercise its beliefs would mean that there are more homes available for kids, not fewer. And so the city failed to show a compelling interest. So you're looking at specific religious practices when you're applying strict scrutiny in this instance, and you're looking at long-standing historical practices as a baseline. So when the government wants to disapprove of a religious practice, if it's been existing for a long time, it's going to be hard for it to meet strict scrutiny to overcome the stand of its policies. And I think that, there's two things about Fulton. I think when you look at this case, you see the court trying to find a way, and I think this is a common feature in the Roberts Court. It's addressing these culture war issues and is trying to find a constitutional solution that will allow both sides to live in freedom alongside each other without squelching each other. And I think you see the court wanting to address the culture wars with a light touch and taking incremental steps. So Beckett represented the petitioners in that case. We asked the court to overrule the Smith standard, but we said we can also win because it's not a neutral and generally applicable law. And the court chose to take the latter argument because it didn't. So where it didn't need to overrule precedent, unlike in whether it overruled Lemon or abrogated it or or abandoned it, it didn't need. It did need to kill Lemon. The court decided it didn't need to kill Smith and Fulton. So you do see it taking a more incremental approach there. Moving forward, I think we will continue to see the court turning to history to determine First Amendment claims. And if it does decide to overrule Smith in a future case, history will be a part of that test. And I think one thing we see from the Carson case is when you have the government trying to choose who gets funds, instituting neutral programs, and in lots of other situations, you'll see more church autonomy implications. So is the government policy interfering in what the church or the religious organization believes? So in Carson, you had the oral argument the justices were asking the Maine Solicitor General, how do you decide if the school is too religious? They were saying, well, we're not discriminating based on status. We're not excluding all religious groups. We're just excluding the ones that use the funds for religious stuff. And then justices were asking questions like, how do you decide that? And they're like, well, we look at the website. we can just tell if they're religious or not. So then you have the government trying to either coerce or I would use the word control what the religious beliefs of the organization are. And I think when you look at Fulton and you look at Carson, I think the next step in the Carson line of cases, this is the next step may be a government that wants to exclude religious groups from a neutral program on the basis of its non-discrimination policy. If you choose who you hire based on your religious beliefs, or if you admit students based on your religious beliefs, we're not going to offer you the funding. And I think when you look at Fulton and you see how the Supreme Court has applied non-discrimination laws under the Free Exercise Clause, I think there's a hint about where the court is going on that. And if I can just respond on the Kennedy thing, looking at the Establishment Clause, moving forward, you see the court building on the Town of Greece decision. And that would be the
Forgot to mention that one. Yeah.
Where there was a challenge to legislative prayer at the beginning of a legislative session. And the court said this was something that the founders actually practiced in the first legislative sessions that they when they were starting to draft the Constitution. We look at the history and we can see that this is a practice that has been happening through history. So we can tell that it didn't violate, but the founders did not think that that violated the Establishment Clause. But the broader question, you don't know, praying, kneeling at the 50-yard line, you don't know if that's a historical tradition or not. I think the broader question is what constitutes an establishment, requires a broader look at history. And Justice Gorsuch's concurrence in Shurtleff, he cited Michael McConnell's research on the Establishment Clause and the Free Exercise Clause. And in Kennedy, the Coach Kennedy case, Justice Gorsuch's majority opinion cited the same research. And that research says there's 6 elements of an established church that the founders recognized. The founders knew what it was at the time of the founding, and that's what they were trying to run away from. And those are factors that we can look at now to tell us what would be an establishment of religion that would violate the Establishment Clause. That's government financial support of the church, so that was compulsory tithes and land grants to the church, and actually it didn't include support for religious schools. Government control of the doctrine and personnel of the church, compulsory church attendance, prohibitions on worship, restrictions on political participation to members of the established church, and government assignment of important civil functions to church authorities. And within all those categories, Michael McConnell sums it up and says the key element of establishment was state control of religious groups. And so I think we'll continue to see coercion. We'll continue to see some of these strands play out, and I'll be interested to see what does happen if there's another school prayer challenge. I think if you have the school authoring prayers, that's arguably control of religion. But I think we'll see more of a focus on these historical terms.
Great. So let me make a broader point about constitutional law. Right? The court has framed the inquiry in a couple different ways. They say text, history, and tradition. And it's the tradition part that sort of tickles me a bit, right? What's the difference between history and tradition? In my mind, history is the stuff that existed when the amendment was framed in the 1790s. But what's tradition? If you look at another case called American Legion versus American Human Association, tradition played a role there, it seems, right? You had, not too far from here, in Bladensburg, Maryland, a cross in the middle of an intersection. It was a peace cross erected to honor the soldiers who served and died in the First World War. And this was a case from a couple of years ago. The court seemed to suggest that, well, there was this tradition of simple crosses used to honor the dead, and that was not necessarily a religious symbol. Justice Gorsuch wrote a concurrence saying, who cares about the tradition? It was either valid at the time of the framing or not. Right? Who cares about tradition? Look at the Second Amendment context, right? New York had a gun control law in the books for almost 100 years. Is that a tradition or not? Many states with the Blaine Amendment started banning religious school funding in the late 1800s. We're talking about a century. Is that a tradition or not? So I agree with the Beckett brief in the Carson case and others. My problems with the court. Once they say text, history, and tradition, they are potentially opening up the lower courts to make mischief. And that's why I'm not a fan of the test. I agree with you. At the time of the framing, there was definitely funding for religious schools. There's not a question about that. But there's now some sort of long-standing tradition that could perhaps trump that history. Anyway, the court's doctrine here, I think, is sort of evolving. And I don't know where they wind up on both First and Second Amendment. But whatever direction it is, it's the opposite direction of what the court did in the 60s, 70s, and really the 80s, which favored the strict separationism and minimized the scope of free exercise almost to a non-fundamental right status. All right. Questions?
Yeah.
Well, thank you. Thank you. You can clap. Please clap. And I'm sure we're happy to take questions.
The Establishment Clause, I feel, is like outside of these direct authorities that you're speaking of, these 6 factors. Those are pretty like overly direct, like it's like explicit. So is it kind of think the court's opinion and right leading like opinion that outside of these direct spot the establishment clause really doesn't speak to any kind of endorsements? It's quite in a school where they allow, they acquiesce to every teacher training. Well, but the school doesn't like say no, that things awesome. That doesn't speak. It's very hard to see that as not being the acquiescence or the allowing of it seems to be kind of like an implicit response. That wouldn't be a direct response.
Yeah, I think if you want to have, like, a teacher praying in school is sort of what, the Kennedy case addressed. I think one thing you've seen, one thing you've seen in these cases over time is that the establishment clause and the free exercise clause aren't supposed to be in tension with each other.
Correct.
They're supposed to complement each other. So you don't want the court, or you don't want government establishing a religion, and that the purpose of that is to protect the free exercise of faith. So if you have a teacher who wants to exercise his faith by praying, I can, as long as students are being coerced or are being told to pray, I think, or required to pray in some way. I do see, I think it's a harder case. It's harder to make the coercion case. So I do think you're seeing less. Maybe the school district is establishing a religion. If they have dictate, draft a prayer and have it read over the intercom every day. But if you just don't have a policy at all and you don't stop your teachers from praying in class, maybe that's not an establishment.
Every club. You know what I'm getting at.
Like a culture.
Right, I mean,
Like,
you're not supposed to-
how about after, say, the Pledge of Allegiance, you say the Lord's Prayer? Is that what you're asking about? Like that example?
that would definitely-
But is that direct coercion after the Kennedy opinion? Just saying it. A teacher leads it. Students don't have to recite it. They don't have to stand. They can just sit there while it's being read.
I think it's. I don't know if it's coercion, but I would say it's government. I would say it's an establishment of religion. You have the government reciting, government. The schools requiring the recite.
What about Stone v. Graham and a moment of silence? Just a moment of silence for you to say whatever you want.
I think that's not an establishment.
So the Supreme Court said, Alabama, right? Alabama case in the 80s, that merely having a moment of silence for you to say whatever you want to say was a self-established clause violation. That I think is now.
Yeah, I haven't read that case lately, but I do think that was it was after the school prayers decision. They were like, oh well, this practice, this under their breath, it was supposed to be prayer, and still coercion. But I think.
Mhm.
I think a moment of silence is not establishing any religion.
Yes, sir.
Wasn't one of the key arguments in Kennedy is that after the game, sort of a mishmash of time as to whether or not he is officially acting as a employee of school district versus, so that might be a difference in a classroom.
Correct.
Because I would assume that saying the Pledge of Allegiance means that the clock has tolled and you're now in class. You're not teaching. The expectation is that the teacher is acting in line with their job description.
That's right. You may have studied, there's an entire line of cases involving government speech, what's called the Pickering Doctrine, right? That if you're a government employee, you generally have reduced speech rights. So if you're a teacher, a public school teacher at least, you have reduced rights to speak in class. Coach Kennedy said that after the game was over, he was on his own clock. He could do whatever he wants. He could check his phone. He could do whatever he wants. This issue was, I think, in some dispute, but the majority said no, he was on his own time, and this is why he wasn't doing it during halftime or in the locker room, right? It was supposed to be after the game.
Can I ask a follow-up question about the Blaine Amendment? The Blaine Amendment, the argument was that not including what was happening in New England prior to the formation of the United States, what's the point was not to endorse non-cultural mainstream religions, right? It's trying to put an end to Tammany Hall getting state money for parochial.
What time did
Right,
you finish?
right, the Blaine Amendment,
So I'm so sorry to cut you a little bit off. We do have a class that's about to start in 5 minutes here.
Okay, so maybe you want to answer this question, just let Dan answer this question? Yeah, I'm sorry. And we'll answer questions in the hallway. Happy to do it.
the idea about the Blaine Amendments was that well, public schools were culturally Christian, they were culturally Protestant. And then, so the Catholics came in and said, we would like, if the public school is gonna be Protestant, we'd like money for our own school. And so across the country, there were, there was a lot of violence, and there were all these laws that were passed to say you can't be sectarian, which meant Catholic, you can't be Catholic. But they continue to have Protestant leaders in the public school. So the history of those laws is discriminatory against Catholics and Catholics. And that's why they are, like, that's why you've seen the court disapproving of them in the last couple of months. And that's been the case in the course of this.
All right. I'm so sorry, we're out of time. Happy to answer your questions up front. There's another class coming in. Thank you so much, everyone.